Good morning.
Good morning.
Madam Chief Justice, my name is Krista Pratt. With me is Carla Eaton. Together, it is our honor and privilege to represent the Fredericksons in this case. Amanda Frederickson and her parents, Michael and Susan Frederickson. This case begins with a complaint of rape. There is no dispute in this case that on July 2nd, 2002, Amanda Frederickson went to the Shrewsbury Police Department and reported that Neil Benoit had raped her. And in fact, she reported that over a period of a year from 2001 to 2002, he had raped her on several occasions and in fact had molested her when she was a small child. As part of this complaint, she also alleged that Neil Benoit...
But those are allegations, right? So we get to the probable cause hearing, and what happens?
Yes, Your Honor. At the probable cause hearing, Ms. Frederickson, who was intimidated by an investigator, a private investigator, retained by the defendant in that case, was too afraid.
She claims.
Excuse me?
She alleges.
She alleges. And she reported this to the district attorney as evidenced in his affidavit that was submitted as in support of her motion for a special motion to dismiss under the
Did she
anti-SLAPP
report
Act.
that to the district attorney that day?
Excuse me?
Did she report that to the district attorney that
She
day?
did. She did. And she
And
told
were there
him...
steps taken?
No, at that point she was too afraid to testify. The communication to the district attorney that day was simply that she was not prepared to testify at the probable cause hearing. Assistant District Attorney Murata, who submitted the affidavit here, did testify in that affidavit that at no time did he believe that the criminal complaint lacked probable cause to proceed.
No, I understand. That's his belief.
That's his belief,
But
correct.
did the assistant district attorney attempt to draw to the attention of a judge what is a very, very serious charge of interference with a witness?
Well, Your Honor, it's
What-
unclear. By the time that this complaint was filed, nearly 3 years later,
No.
the record
At the
had been
time.
lost.
At the time.
At the time, I'm not sure. I'm not sure what he brought to the attention at that point in time.
Was her complaint to the police department petitioning?
Yes, I think that is clear based on this court's precedent, that activity of reporting a criminal complaint to the police department was petitioning activity under the two-part framework that this court has established.
Okay, if that's the case, then isn't the next question whether the affidavits show no reasonable factual or legal basis?
Correct, Your Honor. Then it moves to the second stage, and this is where the lower court misapplied the law. Judge Murphy conflated the two parts of the test, held the Fredericksons to a heightened standard, legitimate petitioning activities. This court, in its rulings, has made clear that the motive or intent of the petition or legitimacy of the petitioning activities are not relevant at the first stage. And that is because at the first stage it's a minimal burden on the moving party. At that point it shifts, the burden shifts to the non-moving party to come forward with sufficient evidence, preponderance of the evidence, to establish that the petitioning activities were utterly devoid of any reasonable basis in fact or law.
In fact, I'm not sure I understand this legitimacy requirement that Judge Murphy inserted, because many times movements have very, well, we've said that the motives are irrelevant, and many times they have personal gain as the entire motive.
That's exactly right, and certainly in any case that alleges malicious prosecution, for example, malice will be alleged as an element of the claim. So that cannot be the standard. To hold otherwise would eviscerate the purposes behind the anti-SLAPP statute of placing a higher burden on the non-moving party to substantiate the lack of merit of the original underlying petitioning activities before he can proceed with these types of claims.
And
So
I
now-
take it, go ahead.
So now we get to the very tough issue is how does a superior court assess whether the non-moving party has met their burden when you have affidavits counter on the same point without a hearing, assessing credibility, something of that sort?
That's an excellent question, and it's a point that we raised below. There could be an opportunity for an evidentiary hearing. It was not requested. The non-moving party did not request an evidentiary hearing, nor did he request, as he's permitted to do under the statute, any specific discovery. Although the statute contemplates that discovery will be held in abeyance and stayed during the pendency of the anti-SLAPP motion, there is a provision under the statute for the non-moving party to request limited or specific discovery, and that was not done here.
But could you theoretically read what Judge Murphy was doing as kind of substituting his view that the non-moving party should have asked, and he was going to give him the opportunity to do that limited discovery?
I think based on the record that we have below and based on the rulings that we have from Judge Murphy, that what he did was substitute his judgment for what the proper standard is in this case. He did give the non-moving party, Mr. Benoit, the opportunity to submit affidavits, for example. Mr. Benoit's counsel at oral argument, at motion hearing, had represented that there were 4 alibi witnesses who could substantiate Mr. Benoit's whereabouts on the night of the rape. When push came to shove, in fact, he only submitted 2 affidavits, both of which Judge Murphy disregarded in ruling on the motion.
Well, even if you consider those 2 affidavits, there are gaps, I take it, in the time,
Absolutely.
which may have obviated the necessity to have a hearing.
Correct.
An evidentiary hearing.
Our position is that it wasn't required. They failed in meeting their burden as far as what they submitted. If they needed more evidence, he could have requested it.
So
But certainly the affidavit, the affidavit of Mr. Hartman is ambiguous at best. It simply states that from a time frame from 12:30 a.m. to 10:30 a.m., he was with Mr. Benoit. Similarly, Mr. Preeper's affidavit contains holes and does not account for Mr. Benoit's whereabouts for the entirety of that evening. And none of the affidavits submitted substantiate any sort of alibi for the prior incidents of rape or provide any evidence whatsoever regarding the molestation charge that derived from when Amanda was 3 or 4 years old.
Now, the police report does not indicate the point in time on, I think it was June 30th, that this alleged rape occurred.
Correct.
And was there a motion for a bill of particulars in the criminal case?
We don't know because the records were destroyed by the time that this case, the incident civil lawsuit was filed. I don't have access to those. We requested them from the district attorney's office, but, from the court, and they were not able to.
What do you mean they were destroyed? How long do they keep their records?
3 years.
Yes, and it was right on the cusp. This was on the cusp of running the statute of limitations, so by the time this issue came up.
Ms. Platt, could I ask you, it seems to me that whatever we think about the state of the evidence to reach the second prong of the second part, that this complaint is brought against both the alleged victim and her parents, correct?
That is correct, Your
Is
Honor.
there anything in the record that would, do you see a distinction between, I recognize that you represent all of the defendants, but do you draw a distinction between the alleged victim and her parents?
I think there's even less, I don't think there's any evidence in support of either, but particularly with respect to the Fredericksons, Michael and Susan, the parents, there's no, it's clear from the record that the only basis for the complaint was their activity in reporting and supporting Amanda in her report of rape to the police department, and there's been no evidence presented whatsoever that their petitioning activities were devoid of fact or a reasonable basis in law. All that we have in the record in terms of the police report is that the parents spoke to their daughter, believed her, supported her allegations, and further, Mrs. Frederickson in particular had informed the police that she in fact had caught Neil Benoit when he was babysitting Amanda, exposing himself to her when she was 3 or 4 years old. So that was direct witness testimony.
What is their petitioning activity, though?
Their petitioning activity is, first of all, as parents of a minor child, I think it's not controversial that they would be in the same position to protect the rights of their minor child as Amanda would be herself, but their petitioning activity would be cooperating with the
How
police
old was she?
investigation.
How old was the child when she?
16.
16.
16.
So what would
And
they,
further,
what
that
would
they
it be?
cooperated with the police investigation and provided information to the police, filed a police report to the police department at the time of Amanda's complaint of rape.
Could I ask you one other question? Have you read the amicus brief?
Yes, I have, Your Honor.
The recommendation of the amicus brief is to send it back with guidance. Do you agree with that?
That is the point on which we diverge from the ACLU's brief. In fact, given the long passage of time for this case to reach this point, nearly 3.5 years, we are representing the Fredericksons pro bono, but had they had to pay for counsel in this case, it would have been extremely costly, a costly proposition. The purpose of the anti-SLAPP statute is to provide individuals with an immunity from lawsuit, to remand this case for further proceedings, which is simply...
In any case, we have, am I correct that we have in front of us everything that the motion judge had in front of him?
Except for certain pleadings in the case, but yes, all of
I mean, we could get the pleadings in the case, correct? There was no oral testimony, there's no witness credibility.
There was, just to clarify, there was deposition testimony and other evidence taken after the anti-SLAPP motion was denied the second time, because the lower court refused to stay the proceedings pending the outcome of our appeal to the appeals court. So there was subsequent discovery taken. Our position is, though, however, all of the evidence that was before the trial judge in the lower court is before the court today.
On the anti-SLAPP motion?
On the anti-SLAPP motion, and it is our position that, in fact, the court should rule on this motion.
I saw that you had asked that, but I realized that the amicus brief was filed after, and I just wondered if that had...
Could I ask you a question? I don't see the statute, unfortunately, it's not in any of these briefs, or at least I can't seem to find it. Maybe it's there. But you're saying that if Mr. Benoit had asked to undertake the discovery that Judge Murphy talked about in his decision before before there was any hearing, that would be permissible? Is that limited discovery relating to the SLAPP motion?
It's contemplated by the statute, Your Honor. It's specifically the statute states, all discovery proceedings shall be stayed upon the filing of a special motion, provided, however, that the court upon motion and after hearing and for good cause shown may order that specified discovery be conducted. And that was not done here.
And so I take it that there was an order to stay, and then there was, when the motion was denied, the stay was either lifted or expired of its own terms.
Correct, Your Honor. And we had requested on numerous occasions that the court be stayed pending the outcome of the appeal, but in fact it went forward until July of last year, when finally the court agreed to stay any further proceedings.
July of 08?
08, yes. And it was by the time the case was in fact stayed, we've undergone substantial discovery, including contentious deposition practice, et cetera.
Ms. Platt, forgive me for asking all of these procedural questions. The appeals court, as you know, relying on its own decision, said that if counterclaims remain pending, that an interlocutory appeal could not be pursued. Do you agree with that holding?
No, we don't, Your Honor. The appeals court relied on its own decision in Baker.
Right.
In that case, for two reasons we disagree with it. First, we believe that the Baker holding is inconsistent with this court's rulings granting or conferring the right to interlocutory appeal to movements in anti-SLAPP cases where the motion is denied. And the purpose of that, again, to go back to the immunity afforded by the statute, unless, and it kind of dovetails with the doctrine of present execution, that the immunity would be lost if that interlocutory appeal right were not protected. So to the extent that Baker is inconsistent with that premise, we believe it was wrongly decided. But regardless, we need not even get there, because there was another decision, Adams v. Whitman, by the appeals court, which is more factually similar to our circumstances, where there were still the granting of the motion to dismiss would not have disposed of the case in its entirety. The difference with Adams was that it involved an anti-SLAPP motion by the original plaintiff. So the plaintiff had filed suit, there were counterclaims filed, and then the original plaintiff had filed a motion to dismiss under the anti-SLAPP statute, which was granted. We would submit that it does not make sense, it would be procedurally inconsistent to hold that it depends on what posture the party was in as to whether or not they would get interlocutory appeal. We'd further note that this court's most recent decisions in Corcoran and Wenger, there were other claims that remained after the ruling on the motion to dismiss.
But
So,
wasn't did the appeals court dismiss your appeal on the basis of Baker v. Hobson?
yes,
So don't we have to decide whether Baker v. Hobson is good law?
you do, but also you know, let me retreat a moment. I don't think you need to. I think you can say that it was wrongly decided based on the court's application of its own precedent, and I think you can rely on the decision in Adams for that result, but we would also request that the court rule that the Baker decision was wrongly decided.
Thank you, Ms. Platt.
Thank you.
Mr. Gordon?
If I may, I'll try to be brief unless there are questions. The facts in this case really, at the time of the hearing before Judge Murphy, are not in dispute. The claim was that, the facts are that on the evening of July 2nd, 2002, Ms. Frederickson, after an argument with her father about not giving her a ride over to the boyfriend's house, calls the boyfriend up and is telling tales of woe, and in the course of that conversation says to him, "I was just raped a little while ago out in a pathway somewhere near my house."
But you have to look at what the record was before the motion, Judge, and he's got, on your side, affidavits that he didn't credit. So what do you do about
Well,
that?
but he's got the police reports, and the police reports give these various stories as the time on July 2nd goes on. So by the time she gets to the police station, or actually by the time everybody arrives at her house, she's now got this story about the assault taking place at 11 o'clock, and that's in the children's report, the children's DSS report, the child interview, that at 11 o'clock she says this assault took place out at the side of her house behind the chimney. That's what she says. That's the report she tells. That's one of the stories that's told to the police that night.
But wouldn't, I mean, under the anti-SLAPP statute, didn't the judge really have two choices? Either say that you, as the non-moving party, hadn't met your burden of showing this had no validity whatsoever, or that you hadn't met the burden and the motion should be allowed. I mean, this conditional, where does that come from?
Well, I don't think he did that. I think everybody's sort of reading differently into what he actually did. What he said was, "I'm going to give you the first two to the defendants. I'm going to give you the first two elements," is what he said. He said, "I'll give you first that it was petitioning activity, and I'll secondly give you, if I give you the benefit of the doubt and say there's no that you have put forward that there was no substantial basis other than or in addition to the petition," he said, "how do we get past the other issue, which is there are factual issues here. Mr. Benoit says it didn't happen. It's happened at 11 o'clock. Those affidavits, even though there are gaps in time during various points of the day, number one, this is a summary proceeding, and whether or not a party can get a hold of all of the witnesses and get the affidavits in a summary basis is an issue. But nonetheless, the affidavits clearly accounted for Mr. Benoit's time around 11 o'clock that night and put him in Lunenburg, Massachusetts, 30 miles away in the North County that night at around, and for time before and time after this alleged assault took place. So that was before Judge Murphy. Also before Judge Murphy was Mr. Benoit's own affidavit saying, "I wasn't there, I was in Lunenburg, I didn't do this." He was in the police station, according to the police report, for several hours, voluntarily spoke to the police, gave them statements, and kept telling them, "I wasn't there, I wasn't there," and the police never attempted to verify his whereabouts that day. So by the time, and then simply went out and arrested him based upon this report that came in on July 2nd with conflicting stories of when this alleged event occurred. Those are the facts. That factually is what occurred at the time of the incident. Now, they make this thing out about the private investigator intimidating or claiming that he intimidated the witness. There's no evidence of that whatsoever. And in fact, when we showed up at the Westboro District Court, the district attorney made no attempt to ask for a continuance, made no request to the judge for any relief, did nothing except came up and said, essentially, we're not going forward, period, and that was the end of the case on that morning. It was a two-minute appearance before the judge, and there was no request for a continuance, which, had there been, I think would have, given my experience in that court, would have been granted. So that's how this came about. It was
When
dismissed.
did the claim about the intimidation first occur?
Well, I first saw it in the pleadings, but they're saying it apparently first occurred when they went in to see the district attorney that morning. I never heard any such claim.
Is there anything in the record about this claim, by the way?
What, the intimidation?
Yeah.
Just some claim, actually, no. I mean, it's just these claims that the...
Isn't it described in the affidavit of the assistant district attorney?
That's the point, that's the only point it is. I mean, that's the only claim. And the only affidavit that was really brought in to raise the issues under the motion, in support of the motion, was the one affidavit of Amanda Frederickson, which said the assault took place on July 2nd, when the fact of the matter is the claim arose out of allegations that occurred on July 30th, 2002. June 30th. June 30th, 2002, for which the criminal complaint was issued. It had nothing to do with July 2nd, and then her subsequent affidavit says, I don't remember when this occurred. So when you get to the question of the first two elements, whether or not the claim was based on a substantial, whether or not she could show that the claim against her was based on something other than the petitioning activities, the fact of the matter is the claim was based on a June 30th allegation for which the complaint issued, and she's saying, no, it's July 2nd, which doesn't raise the issues in the civil action that we brought. And so that on that basis, and they continually claim that they are being somehow prejudiced, or that the argument is that this arises out of the petitioning activity, they never raised that issue. The other fact of the matter is the claims by Benoit are substantial outside the basis of the petitioning activity.
But would you agree that the judge below could have had an evidentiary hearing if he couldn't decide on the basis of the affidavits?
He could have. I've never seen that done, and it's rarely even done in a summary judgment proceeding, and rarely done in a preliminary injunction proceeding. So
I take it that neither party requested an evidentiary hearing.
I didn't, and the judge never suggested it. You've never
No, but the moving parties didn't sit.
No, they didn't ask for it. But this court in McLaren, in that case, specifically did not abrogate the claim for malicious prosecution, because that was the basis of the McLaren claim, and the reason that McLaren lost was on the credibility issue of the truth of the claims made against him, because they were resolved in the 209A action when the 209A restraining order was issued. So he lost on one of the 5 elements, which knocked him out, and the court said malicious prosecution is not abrogated. Now, the fact of the matter, the question becomes, I suppose, if you're going to look at these cases, what the standard is that the judge has to look at when he's deciding these motions. If there are factual disputes, and Judge Murphy went over this. This hearing went on for a couple of hours. He went over this painfully. This was the second hearing on the same motion that they had brought, one back in February and the later one in July, where he said, I'm looking at this, I've got 2 conflicting sets of affidavits, 2 conflicting views of what occurred here. And he said, I can't say, or how do I say that you're wrong or you're wrong? I can't do that. He said, how am I supposed to do that? And the question is, the defendant's position in this case is that their view of the facts is absolute. It cannot be challenged, that you have to take the defendant's allegations of fact as gospel, and the plaintiff essentially can never refute those facts if you read their brief and their materials, which cannot possibly be a standard, because Benoit has his right of petition for redress, as does everyone else.
So how would you articulate the standard that your client needed to meet in this case?
In my brief, I refer to the California statute and the standard, because I think it's a due process, and I think it's an equal protection right, which the standard is, has a party, in this case the plaintiff, who is the non-move-on, shown a prima facie case. Are the elements there to show that he has a case that has nothing to do with or is outside or is a valid case that really is not arising solely out of the petitioning activity?
Well, let's get beyond that. Let's assume let's assume that this is petitioning activity. So you have the burden, but we said by a preponderance of evidence.
Which there's no case that defines what the preponderance is.
That's why I'm asking you,
Okay.
how would you
If
view
it were
this?
me, the problem, and I said this in my brief, the problem with the preponderance standard is, are we to read into that we have to have an evidentiary hearing to eyeball the witnesses and determine credibility? Do we line up the affidavits and say, gee, who do I think is more truthful? Because preponderance inherently means that there's a credibility issue. And if you're doing this on a summary basis, as in summary judgment, then you have to take, then you cannot do a credibility weighing between the affidavits. So I think if, on that level, you have to take the affidavit of the non-moving party and assume the facts set forth therein are true, along with the other inferences to that benefit. And then look at the elements of the claim, and if the non-moving party comes about and says, I've got the elements here, and it really is not the petitioning activity, which in this case, it's not the petitioning activity that gives rise to the claim, then that claim should go forward. And I think that's what happened here, and that's clearly the situation in Benoit.
Why isn't it the petitioning activity?
Well, because, first of all, the claim, the malicious prosecution is based upon the false statements, the falsity of the allegations made of the criminal complaint.
Well, but that's the petitioning activity.
Well, no, the petitioning activity is going to the police. If you, and the U.S. Supreme Court and the other courts that have considered this have all said there is no immunity of any kind for making a false statement regarding someone. And there is no, and the defendant's position is that this statute is a full immunity, that there is no exception to it. It is a full immunity to any conduct in relation to any type of petitioning activity. This court and any other court that's considered the issue has said, no, it is a limited or restricted immunity so long as these elements are, so long as one of the things is it has to be a good faith and it has to be a truthful statement to the authorities. And in fact, I was reading over the case that just came down from this court in American versus, was it Bayside? I don't even remember the name of it at the moment.
American Expositions against
The
Corcoran.
exposition case, where on, and I've got the printout, and it doesn't have the exact pages, but at the bottom of the printout on page 9, on count 3, the discussion turns to whether the claim arises out of protected petitioning activity, and in this case, in the Bayside case, it was found that the conduct could not be said to be tortious or to have been made in bad faith, which, as I read this in the time I've had to read it, means that if the conduct under count 3 for the tortious interference had been tortious or bad faith, meaning false statements, wrongful conduct of that nature, it takes it out of the petitioning activity. And that is consistent with, and all of the courts that have considered it, the issue of false statements have said there is no immunity, limited or otherwise. There is no immunity.
Mr. Fox, excuse me, I mean, not Mr. Gordon.
That's okay. I've been called worse.
I'm looking at Wenger against Aceto, which seems, I mean, it's close in this sense that because it was a claim of malicious prosecution. And in that case, Justice Glaney goes through, and this was attempted larceny, and goes through and makes a factual determination that the person who initiated the complaint, in the words, had a factual basis for filing the application. I take it that the difficulty in this case is that, unlike larceny, it really is not possible to determine whether or not the complainant, the alleged victim, had a factual basis for filing the application until somebody determines what took place.
Well, yeah, except in Wenger, it was admitted that the check bounced.
No, I understand that.
So that was a factual basis. And whether they issued the complaint for whatever reason, who knows what goes on in the district court clerk's office of mine sometimes if they didn't issue the complaint.
But that's really my point, that there was in fact some
Objective, hard evidence.
objective hard evidence. Here you have what ultimately will come down to a credibility test, correct?
That is in some ways true. But my argument has been, and you heard that there were depositions taken after the motion was denied. And they took, the defendant took depositions of all of the, they want to call them alibi witnesses, and others, all of whom put Mr. Benoit in Lunenburg that night for hours before and the day afterward that this alleged assault took place. So that evidence is out there, and they know it's there. And these witnesses, some of them, one of them was his ex-girlfriend.
No, I understand the point, but I'm really...
I'm sorry, let me back, because I lost my train of thought for a second. But my point is that if you're looking at the evidence here, and I think if you're trying to look at an objective standard, you have to look at, say, well, this is what she says, but countervailing that, what do we have? We have two different stories within an hour or so of each other. We don't have any forensic evidence whatsoever, nothing to show it. We've got the story about being dragged into the pathway at one time earlier in the evening, and then it happens behind a chimney later on. I think there's sufficient evidence here, taking a summary judgment standard, for example, and saying, taking the inferences most favorable to the non-moving party, that there is evidence here that Mr. Benoit is right and he didn't do these things, coupled with his denials and the police report that says he was there for 4 hours, several hours, maintained, gladly cooperated.
No, I understand.
And I think that inference is lack of consciousness of guilt. I mean, that's all I can say about the other choice is, I suppose, that you allow a case like this to go forward.
That's my point.
And do the depositions, which they've done, and establish that the alibi is, unless you disbelieve 4 people, other than Mr. Benoit, they're telling the truth. There's objective evidence that he wasn't there.
Thank you, Mr. Gordon.
Thank you.